cross-examine the deponent, Mr. Joshua Yamazima. The reason for the application for cross-examination after the timelines have been set is that we were served after those timelines. And we could not have made the application earlier because we had not been served with an affidavit in reply at the time that was set the timelines. The second ground, Your Honor, is that given the period, we were unable to file our submissions in rejoinder in time. But we were able to file them and upload them on ECMIS. We were able to upload them on ECMIS, Your Honor, as we had waited for court's guidance on the request for cross-examination. Your Honor, we had not made the application orally and substantiated it. Since proceedings, criminal proceedings are oral. We had given court notice, and we also note that the court on that letter appears to have not taken into account the fact that the events had not happened. So there could not have been overtaking of events before they happened. Your Honor, the affidavit was filed after the timelines had been set. So it could not have been overtaken immediately.
So we
would have been able to make that application immediately before court.
So the time we have not uploaded them.
Yes, we've uploaded them on ECMIS, our submissions in rejoinder.
Too late.
Or it will be later. So we pray that the court, in the interest of justice, get pleased to consider them because this matter and this application raises a very fundamental issue on the rights of an intended accused person to be heard at a preliminary stage. And Your Honor, as you may see from our submissions, it's a matter that has not been canvassed in our jurisdiction, but it is a matter that has been explained in the Kenyan jurisdiction and in other jurisdictions. Therefore, in the interest of justice, Your Honor, we pray that you be pleased to arrest your judgment. Resolve the issues at hand, consider the issues at hand, and Your Honor, the courts may thereafter be pleased to deliver this ruling. So pray.
Yes, Mr.
Yes, Your Worship. Categorically, we have the submissions of counsel, but I want to address this court on only two major issues. On the late filing of their submissions, as a qualifier to arrest this ruling, Your Worship, the applicant counsel filed their submissions in their application outside the limited time that was provided for the court. And that will be them,
Yes, for your submission.
yes, file their submissions past time that was allocated to the court in its directions. So, Your Worship, they cannot implement to benefit from this very negligence. 2, we are here for a ruling in this case, and all issues that are raised by the applicant counsel were addressed in our pleadings. We are ready on court report. And so we believe that court considered all of them. And all will be resolved in the ruling that should be delivered. Secondly, now just can we get a record of this particular letter?
So that means someone else and put it as well. And with that man has been settled.
The submission is that you cannot arrest the judgment on the grounds that he has raised, because in Joshua's affidavit, in paragraph 1, he actually describes himself as the complainant in this criminal case. So he does not deny, file the complaint. So that cannot be a basis for an arrest your if this will Your Honor, I'll address you on the first response on submissions. Your Honor, when we wrote to this court requesting it to adjust the timelines based on the inconsistencies and denials in the affidavit in reply, we did not receive any formal communication until a note was registered on it on the 8th of January 2025. Your Honor, that is just 8 days ago. So Your Honor, that is when the communication came. So we had filed submissions, and respondents were able to file their submissions in response. And Your Honor, it would just be fair, and there is no prejudice to any person for this court to extend its generosity in the circumstances and allow to consider the submissions in the joint, given the technical aspects that are raised, for which the input of the applicant's counsel would help in guiding courts onto the right path. Your Honor, Mr. Tony Tomokunde has submitted that the issues were considered in the affidavit in reply and in the submissions. Your Honor, we strongly reject that response. Your Honor, in his affidavit in reply, Mr. Joshua Yamazima, and specifically, Your Honor, he said there was a response and referred to the affidavit in reply, which we are now responding to. Unless he retracts that submission. He referred specifically to an affidavit in reply. Court that he denies filing the complaint on oath, which we submitted and attached to the application. Your Honor, there are inconsistencies in that affidavit which cannot be resolved without.
Is a right to cross-examine.
Absolutely. Your Honor, that is why we apply it, because it's not. The court has the discretion.
Can court accept that discretion at this stage to the trial?
Yes, Your Honor. Whenever there is an affidavit.
What I'm saying,
Yes, Your Honor.
the right to allow part of cross-examine is not absolute.
Yes, Your Honor.
We are at a point where we are here to ruling. Council applies to arrest the ruling position that court should exercise its discretion and allow cross-examination. Let's start justice.
Yes, Your Honor, it serves justice because immediately after filing the affidavit in reply, we wrote to court on the 11th of December 2025. We wrote to court on the 11th of December 2024. Immediately after receiving the affidavit in reply, the justice that should have been served at that point was for court either call us and give us a ruling on our application to cross-examine. We did not receive any hearing notices or any response. Your Honor, there will be no justice for court after 8th of January 2025 to say that, well, it's now overtaken by events. We applied before even any events took place. Upon receipt of the affidavit in reply, is it fair, therefore, for courts now to deny us this application and say it's overtaken by events, which events had not happened in the first place, but after the receipt of the affidavit in reply, we wrote to courts. And the only response we had was on 8th of January 2025.
Finally, Council.
So, Your Honor, there are grave inconsistencies in the affidavits which court cannot resolve unless there is a cross-examination. Your Honor, on one hand, the complainant denies filing an oath, which was attached, and he specifically mentions that paragraph. Paragraph 5 of that affidavit in support, we attached the complaint, which he denies filing. The other denials that have been made, including withdrawing instructions, it would have been different. It would have been different. In their submissions in reply, for good reason, to dismiss the complaints.
the parties in this application agreed that they will proceed by all time of student submissions. The court noted the parties' timelines within which file pleadings and submissions. Both parties did file their pleadings and submissions, though the timelines were not adhered to. Court keeps this case for ruling today, the 17th of January 2025. Counsel for the applicant, Mr. Didik Pasipita, now seeks to arrest the ruling on 2 grounds. One, that they seek to cross-examine Mr. Joshua Yamazima on his affidavit in reply to the application. And that the court should also adjourn this matter to consider their submissions in rejoinder which were filed late. The right to cross-examine a deponent is not absolute. Court can grant the parties the same if it serves the ends of justice. I have had the chance to peruse the pleadings and submissions of the parties, especially those of the applicant. The matter in which the counsel for the applicant seeks to cross-examine the deponent was well conversed in their submissions. No injustice should therefore be suffered by the applicant if this court declined to allow the applicant cross-examine Yamazima Joshua, most so at the time when the case is ready for ruling. Courts cannot adjourn a ruling because the applicant told his submission during the late. Yet courts set timelines. This would encourage laziness by advocates and impede backup. For those reasons, I decline to arrest the ruling. The same shall be delivered today on FTPs by cause of business. The main case also will be, the ruling for the main case also will be delivered today by cause of business on FTPs. Most things will come today by cause of business by FTPs.
Tubadde mu nsonga za Ssemakade. Balulinze naye tebiwedde, bagenda biteeka ku Ikimizi. Mu bbiri ku bibadde mu kkooti. Kati ninyo okay.
Amanyi agange nze Ssewaluwala. Kakati ebibadde mu kkooti olwaleero, kkooti yali yayongezaayo omusango guno okujja leero okutuwa ensala. Naye nga tennatuwa nsala twali twasaamu okusaba tubuuze ebibuuzo ku bantu abaawaabwe omusango guno. So nga twateekamu kkooti yatuwa guidelines okufayiringa submissions n'ebirala ebigenderako. naye olwaleero tuzze wano eno tutegeeza kooti tubadde tusaba okubuuza ebibuuzo abantu abafa omusango nga kooti terinawo nsala yaayo buli naye kitwewunyisizza nnyo nti omulamuzi aganye okusooka okutukkiriza okubuuza ebibuuzo abantu abo abawaabwe omusango kubanga mu mpaaba zaabwe ne mu bujulizi bwabwe beegaana okuba nga baakola ki bawaabwe omusango ensonga lwaki twali tusabye kooti kijje tubabuuza ebibuuzo.
So omusango guddamu ddi omulamuzi amaliriza akomekereza atya?
Kakati omulamuzi tatukkiriza kubuuza bantu bibuuzo nife kyetulowooza nti kiryanife era n'agamba agenda mu maaso n'okutuwa ensala omusango guno ne application yaffe okusaba twali tusabye olwaleero ne mu musango so nga weweetegereza application yaffe erina effect ku musango owulidde naye agambye ensala zombi agenda kuzikira olwaleero tetusuubira nti si kyamwenkanyi naye katulinde kinaava mu nsala tujja kulabirira
twewanziza se kansoolisanyu naye yadde kakyayi Council Derek, nzija nsome namba.
Jango some ntonizi Derek kangende kyavuze
Webale nnyo.
nde bisigadde ku gulupu tubaako era tukola njala bakose njala naye
Webale nnyo okubeera nti n'obeerawo. Omwami ono
Ssemakade musajja waffe tetusobola kumuvaako.
Naye wafaanana Wanda, wafaanana Council Wanda Samuel.
Wanda mumanyi naye simufaanana tulina Luganda wadde
Oluganda teruliwo naye
Number
mufaanana. 103 136 bafulumye bayise wano
Derek nebyo byebikulaga nti ebbaluwa eyo ntuufu oli
Ssemakade tegala bijjayo naye
President mu proceedings nga bwe zibadde kati naawe ngenda kusheyalingira ngenda kuteerako Council Derek.
bibeera bikulaga kubanga
As you've seen, there's been Isaac Ssemakade. It's been Isaac Ssemakade today in court. I mean, the issues of Isaac Ssemakade are pending. The rulings are going to be on IKMIS today. We are reporting live here at Buganda Road.